Now, let's continue. Family Code of the Philippines, Chapter 3, Void and Voidable Marriages. Okay? So, in this chapter, void marriage or marriages which are has no legal effect from the very beginning is differentiated from marriages which are valid but voidable. Okay? It can the effect can be cancelled. So, void marriages, it is defined that void marriages are deemed never to have taken place at all and cannot be the source of right. Okay? It can never be ratified and is not subject to prescription. Okay? By ratified, it means it cannot be validated. It cannot be cured. Okay? And also, it cannot be subject to prescription. So, when you say prescription, so if a certain time would arrive, then it means the happening of that event would validate or cure the defect. Okay? However, in the case of void marriages, prescription will not lie in order for it to be valid. Next is that it can be attacked collaterally. Okay? And then it can be questioned even after the death of either party. So, in the other hand, voidable marriage is considered valid and produces all its civil effects until it is set aside by final judgment. Okay? So, in order to attack voidable marriages, you need to file a case in court. Okay? It cannot be attacked collaterally. It can only be attacked through a direct proceeding for that purpose. And then can be generally ratified or confirmed by free cohabitation or prescription. Okay? So, any defect, it can be cured through confirmation of the parties, through free cohabitation or living together as husband and wife, and through prescription. Also, it can be assailed only in a direct proceeding for that purpose and not collaterally. Okay? So, for example, annulment. You should file a case for annulment. Okay? Next, can be assailed only during the lifetime of the parties. So, in voidable marriages, because it enjoys the presumption of validity, so it can only be assailed during the lifetime of the parties, okay, or the spouses. So only parties to a voidable marriage can assail it, but any proper interested party may attack a void marriage. Okay? So if the marriage is voidable, so it is valid, and the spouses can only assail the marriage. Okay? Third parties cannot assail it. However, in a void marriage, interested parties like parents, children, okay, can assail the validity of the marriage. Okay? Children conceived before a voidable marriage is annulled are legitimate. Next. Petition for declaration of absolute nullity of void marriage may be filed solely by the husband or the wife. But a void marriage is still subject to collateral attack for purposes other than remarriage, such as but not limited to determination of heirship, legitimacy or illegitimacy of a child, settlement of estate, dissolution of property regime. The court may pass upon the validity of marriage even in a suit not directly instituted to question the same, so long as it is essential to the determination of the case. Okay? So, that is the meaning of the collateral attack of void marriage. So, even if there are other issues, it can be raised in that proceeding because it has no effect. Void marriage has no effect legal effect whatsoever. So, marriages void from the very beginning are marriages under Articles 35, 36, 37, 38, and 44. Okay? So, these articles can be found in the Family Code of the Philippines, which I have provided in the files. So, for reference, please read it, class. Also, absence of any of the essential or formal requisites renders the marriage void ab initio. Marriages between persons of the same sex, if celebrated in the Philippines, okay, is void. Marriages where consent is totally lacking is void. Okay? Common law marriages and marriages by proxy, void. Marriages where exchange of vows was not done personally by contracting parties in the presence of the solemnizing officer is void. Okay? So, Article 35. Marriage contracted by any party below 18 years of age, okay, is void. Absence of legal capacity. It is an essential requirement for marriage. Solemnized by any person not authorized to perform marriages. Okay, the rule is not absolute. So even if solemnizing officer has no legal authority, as long as either or both parties, contracting parties, believe in good faith, then he had a legal authority to do so, marriage is still valid. Okay? Not only with respect to the parties to such marriage, but also with respect to third persons and the state. Okay? However, class, you need to prove this in court because what is essential is the good faith. And how you prove good faith is a matter of evidence. If contracting parties will go before a person not specifically mentioned by law as having authority to solemnize marriages, the exception does not apply. Okay? So, next is lack of marriage license. So, marriage license obtained after the celebration of marriage does not cure its invalidity. Next is bigamous and polygamous marriages, void. Okay? Mistake in identity, void in the Philippines. Non-compliance with procedure under Article 52. So, only after complying with the requirements may either of the spouses be allowed to remarry. Okay? Now, let's go to Article 36. So, this article is very important, especially in the case of annulment. Okay? Because this article will serve as the legal basis in order to annul marriages. So, no precise definition of psychological incapacity as to allow some resiliency in its application. Okay? So, psychological incapacity is a broad term. Okay? So that its definition will not be limited. Okay? So, it's broad. It is encompassing, far-reaching. Okay? Whether or not psychological incapacity exists depends crucially on the facts of the case. Psychological incapacity should refer to no less than mental, not physical. Okay? So, incapacity that causes a party to be truly incognitive of the basic marital covenants that concomitantly must be assumed and discharged by the parties to the marriage, which include their mutual obligation to live together, observe love, respect, and fidelity, and render help and support. Okay? So, under the law, those enumerated are the basic, okay, duties and responsibility of a couple. Okay? Observe love, respect and fidelity, render help and support. Okay? So, if the other party is non-compliant, okay, it can be made a basis that such person is psychologically incapacitated to perform the basic marital obligation of a spouse. Hence, the marriage can be annulled on that ground. Psychological condition must exist at the time the marriage is celebrated. Okay? So, what are the characteristics of psychological incapacity? As illustrated by series of Supreme Court cases. As enunciated in the case of Santos versus CA, one characteristic is the gravity of such incapacity. Okay? So, incapacity must be grave or serious that the party would be incapable of carrying out the ordinary duties required in marriage. Okay? Next, grave enough to bring about the disability of the party to assume essential obligations of marriage. Next, illness must be shown as downright incapacity or inability, not a refusal, neglect, or difficulty, much less ill will. Okay? So, once again, this would be a matter of evidence. Okay? In proving psychological incapacity, the one who alleged must prove that the other spouse is incapacitated to perform the essential marital obligation expected of him or her. So, that is why in court, some parties would present expert witness like a psychologist, a psychiatrist, to prove that the other party is psychologically incapacitated. Okay? There is lethal or supervening disabling factor in the person, an adverse integral element in the personality structure that effectively incapacitates the person from really appreciating and thereby complying with the obligations essential to marriage. Okay? So, another characteristic is juridical antecedents. Okay? Must be rooted in the history of the party antedating the marriage, although overt manifestation may emerge only after the marriage. Okay? So, the psychological incapacity must start before marriage. Okay? That's the essence of juridical antecedents. So, the incapacity is present before marriage, but the symptoms was only seen, or the manifestations was only seen after marriage. Okay? So, manifestation of the illness need not be perceived at the time of their I-do's, but the illness itself must have attached at such moment or prior thereto. Last characteristic as declared by the Supreme Court is the incurability of the incapacity. Okay? It must be incurable, or even if it were otherwise, the cure would be beyond the means of the party involved. Okay? Medically or clinically permanent or incurable. Incurability may be absolute or even relative only in regards to the other spouse, not necessarily absolutely against everyone of the same sex. Okay? So, the incapacity must be incurable. Okay? No matter what the other spouse do, it is there. It cannot go away. Okay? Must be relevant to the assumption of marriage obligations, not necessarily to those not related to the marriage. So, these three characteristics must be present in order for your case for annulment to succeed. Okay? So, rule on declaration of absolute nullity of marriages and annulment of voidable marriages. Okay, under a Supreme Court administrative order which took effect on March 15, 2003, the burden of proof to show the nullity of marriage belongs to the plaintiff. Okay? So, in law, there is a saying that goes, he who allege must prove. Okay? So, the three characteristic of the incapacity, the psychological incapacity, must be proven by substantial evidence, okay, that such the other party is mentally or psychologically incapacitated to perform the essential marital obligation in order for the annulment to prosper. Okay? So any doubt should be resolved in favor of the existence and continuation of the marriage and against its dissolution and nullity. A petition under Article 36 shall specifically allege the complete facts showing that either or both parties were psychologically incapacitated from complying with the essential marital obligations of marriages at the time of the celebration of marriage, even if incapacity becomes manifest only after its celebration. Okay? So, expert opinion need not be alleged. Okay? However, in practice, in order to successfully for your case for annulment to prosper, you need to present, though not a requirement of the law, you need to have an expert witness, okay, in order to prove your factual allegations. So, incapacity must be proven to be existing at the time of the marriage, okay? So, even if the manifestation only was visible during after marriage. So, incapacity must be shown to be medically or clinically permanent or incurable. So, declaration by a physician or psychologist is not a requirement. Okay? If the totality of the evidence presented is enough to sustain a finding of psychological incapacity, then actual medical examination of the person concerned need not be resorted to. Okay? Though not a requirement, it is advisable that you present an expert witness. Okay? But in law, it is not a requirement because you just need to prove the three characteristics. Okay? The gravity, incurability, and the juridical antecedents. And then, essential marital obligation must be those embraced by Articles 68 to 71 as regards husband and wife, as well as Articles 220 to 221 and 225 in regard to parents and their children. Okay? So, interpretations given by the National Appellate Matrimonial Tribunal of the Catholic Church in the Philippines, while not controlling or decisive, should be given respect